There you are. Hi, Mr. Caldebilla.
Sorry about that. I was a little slow on the trigger here.
We're all having our technical issues today. All right, Mr. Franklin, you're up.
Good morning, Your Honors. May it please the court, if I may, I'd like to reserve 5 minutes for rebuttal.
Sure.
My name is Jonathan Franklin. I represent Geico Indemnity Company in this appeal. This case centers on a fundamental principle in Florida law, and that's the prohibition against trial judges commenting on or summarizing evidence for the jury. This is a longstanding rule that goes back to at least 1896 when the Florida Supreme Court announced it in Lester v. State. It has recently reiterated its relevance in 2015 in the case of Gutierrez v. State. This was almost 50 years ago codified into statutory law under 90.106 in 1976. This prohibition exists to preserve the jury's role as an independent fact finder. To be clear, a judge may not sum up the evidence or comment to the jury on the weight of the evidence or the credibility of witness. Yet
So
that is
Franklin,
exactly.
let me ask you, my recollection is not all of the supposed offensive comments were made in the presence of the jury. Am I correct on that?
That is correct, Your Honor.
Okay. So I guess I'd like to hear those that really were made in the presence of the jury.
Okay.
And then let's discuss the admissibility of the document at all.
Okay. So first off, let's start with the comment made after the court ruled on the admissibility of the document. And in the presentation of that, the judge stated not all of the information that would have been on those different work orders is in that summary, referring to the summary of the historical data. It is only looking for specific numbers. And so I do think that's important for the jury to realize. That is found in the record 2351 to 2352. We addressed that in our initial brief on pages 8 and 9. The court then goes on in the second instance, right before the jury is about to break for the day and leave, and states and this is who she's referring to, Geico's corporate representative, mentioned that as being a difference, but he did not ask about it, referring to Shazam's counsel. But yes, that's why it would be really nice to have the invoices that show the breakdowns with the part numbers, and the summary doesn't provide that information. That is why I mentioned to the jury, this is only giving us partial information. What's important to understand about this is that the court is to remain coldly neutral, and that requires no comment from the judge intimating any opinion on the evidence. The Supreme Court in Gutierrez made plain all matters of fact and all testimony adduced should be left to the deliberate, independent, voluntary, and unbiased judgment of the jury.
But now this is a summary that we're talking about, right?
It is a spreadsheet of data contained within computer systems.
And even Dr. McClave conceded that he did not have access to or review all the things that might go into creating a summary. Am I correct?
He acknowledged that he did not have access to all the data that was culled from the database and put into the spreadsheet.
So the judge is making objective, accurate comments.
First off, I don't think that's the role of the judge. The judge is to.
Well, the judge has entertained an objection to this exhibit, correct? And is allowing it. Might the judge have said, well, gee, these problems mean it's going to be misleading. It's not complete. I'm excluding it. So might the exclusion of the evidence had been the judge to the alternative, the judge not trying not to let the jury be misled by and allowing it in.
Right. So I appreciate your point, Judge Northcutt. I disagree that.
I appreciate that.
Well, I disagree that that's what the judge was doing. She was commenting on what she thought was important, what information she would want to see, and she expressed that in front of a jury. Her making those statements is entirely different than if trial counsel makes them.
Or if the trial counsel makes that argument and she says, exhibit excluded. This is not a proper summary. It's misleading to the jury. I'm not going to let it in.
If she had made that ruling, then that would be one thing. But what
Yeah.
happened here was she chose to admit the evidence. And as this court has recently dealt with in Geico versus Superior Auto earlier this year in January, the evidence from a corporate representative, and Dr. McLean specifically, is relevant to the prevailing competitive price, as is the, yes, Your Honor.
If I may, Mr. Finn, because let's talk about that case. I was on that panel and I concurred in result only. Judge Casanueva concurred with certain portions. So there's some question as to what the law of the case is on that prior case. So I just want to be able to say it out there. It's not like we definitively, we don't know. So this, I just want to be able to let you know that there's some question regarding whether or not this becomes the law of the case, that the spreadsheet is appropriate in these circumstances.
Sure. The point I would be making, Your Honor, in referencing Superior Auto is the fact that in that case, a jury without any influence from the judge as to the judge's opinion on the evidence, the judge made rulings on the spreadsheet. But those were not, to my knowledge, and it's certainly not recorded in the opinion, were expressed to the jury. And in that case, there was evidence from the corporate representative as well as the experts that went to the issue of the prevailing competitive price. Coming back to the point here that the court is not permitted. This is not just a technical issue, it is a fundamental principle, and it goes to the heart of a jury trial in the state of Florida. That's a constitutional right, as this court knows. And so as I was reading before, from the Florida Supreme Court in Gutierrez, a 2015 decision quoting Lester, all matters of fact to be with the jury, wholly uninfluenced by any instruction, remark, or intimation, either in express terms or by innuendo from the judge, from which his views of such matters may be discerned. Any other course deprives the accused of his right to a trial by jury and is erroneous. The fact that that was a criminal matter does not matter here because this is a constitutional right that every litigant has in the state of Florida. The judge's comment as to what she thought was missing or what the jury needed to understand is important for it to realize are appropriate for counsel to make, not a judge. So by making the editorial comments about the nature of the evidence, the judge crossed that line and it caused irreparable harm. This isn't something that you cure with an instruction. This happened in the context of evidence coming in, and the judge.
I don't know if this is, I hate to say it's harmless error, but your exhibit got in. If your exhibit was denied admission, your case would have been over. End of story.
So I don't know that I would agree that our case would be over, Judge LaRose.
Well, you're trying to prove what you claim your prevailing rate is that you can get.
Yes, and again, I reference and respecting Judge Kazam's participation in the Superior Auto case. That case, the spreadsheet was excluded, but this isn't harmless error because while it may come in, the judge's characterization of it as being less than, inadequate, incomplete is what matters here. And the judge wasn't permitted to do that. The statute's plain. The Florida Supreme Court has been plain. The court cannot sum up or comment to the jury about the evidence. And yet that is—
Well, I'll grant you this, and I have serious concerns about whether this should have been admitted, given its lack of certain things, but I would acknowledge, I think, that if the judge says to the jury, okay, I'm letting this in, but I have some, this doesn't have everything, could suggest to the jury that you're attempted to mislead them. I mean, I kind of get that. So there's a comment on the evidence that doesn't go directly to its admissibility, which might have, in my view, perhaps justified its exclusion, but it was admitted. And the judge then said what she said.
Is there no way, Mr. Franklin, that we could take her comment as being an aid to the jury in defining what a summary is?
The judge could have done that and said it was a summary of various work orders and left it at that. She went further. And so because she went further, crossed that line, and again, quoting from the Supreme Court, uninfluenced by any instruction, remarks, or intimation, either express terms or by innuendo. That's exactly what happened here, as Judge Northcutt just pointed out. The issue becomes, may the judge do that? Put aside the sufficiency of the evidence. The judge, in commenting on it, tainted this trial. Whether we want to acknowledge it or not, if I make a comment in the same setting as any one of your honors, the relevance of my comment may be germane to an issue, but the weight of my comment lacks the same gravitas as one of your honors or any judge. The judge brings to the table that kind of gravitas in the trial, which is why more than 125 years ago, the Supreme Court said, no, judges can't comment on it. That's why it became a law in the state of Florida in 1976 under 90.106. The trial was tainted by this, and the only remedy was to allow for a mistrial and a new trial. In fact, the judge, in hearing argument on the one day after she made the comments, acknowledged, oh, I shouldn't have made that statement. But then the next day she responds as that I didn't make that statement. But the record is.
Didn't she, Mr. Franklin, at the beginning, I think in reviewing the transcript, and correct me if I'm wrong, didn't she at one point said to the members of the jury, you're getting this, so we don't give you all the thousands of invoices. It's almost like she was helping you by saying, you're going to see the summary, you may have a question, we're not giving you all of that. And then later on, I guess I share what Judge Northcutt and Judge LaRose are questioning, like, you know, as a former circuit judge, sometimes you try to help the jury. You're going to get this, you're going to see this. And just so, was it really meant to undermine your position? Perhaps I just didn't see it that way, Mr. Franklin.
Sure. And I appreciate you bringing that question up, Judge Kazan. This isn't about the number of invoices that were or were not admitted. This isn't about how many documents came in. It was the judge's characterization that the summary was incomplete, that the jury needed to understand it, that the summary was missing information. That was something Shazam was free to argue, and in fact tried to argue. It was not for the court to go into that detail. And that's where the judge crossed the line. So yes, I appreciate the judge's objective in trying to minimize the volumes of documents coming in, but that doesn't change the fact that the court cannot comment on or summarize the evidence, which is what happened here. The reference to all these invoices is not the focus. Remember too, that this is about the prevailing competitive price. It's not about the component part breakdown. While everyone may want to argue component part breakdown, the policy is very plain. It's the prevailing competitive price. That's the total price of the transaction. So all these other issues as to whether or not it included how much the labor was or how much a kit cost isn't an issue that the judge needs to speak into. In fact, we get some insight into the judge's view of this when she later references her desire to have the invoices, what she wants to see. It was not about the court's view. That is appropriate for a bench trial. This was a jury trial.
So let's then circle back, because if we come to the conclusion that the trial court was wrong in allowing the spreadsheet to come in, isn't all this goes away? Because I mean, if you look at the propriety of the spreadsheet, you have to be able to lay the foundation for that, correct? As to somebody who, if you're going to do it as a business record, who's familiar, who's the one that put it together, and can someone testify to the accuracy of what's contained? So if we come to the conclusion the trial court was wrong in allowing that to come in,
Understand. I would respectfully submit that the requisite predicate, as we argue in our cross appeal answer brief, the requisite foundation for that admissibility of those records was laid by GEICO's corporate representative. It is demonstrated in the record that she was familiar with the processes. She had been a part of the claims processing team, I believe, as we argue, for over 4.5 years. So I don't agree that the spreadsheet is inadmissible. I do take the position that the court, in admitting it, did not commit error, and I think a necessary predicate was laid.
Could the judge, though, for the reasons that she described and she discussed this exhibit to the jury, decided that the exhibit was misleading and exclude it on that basis?
If the judge were to have, so I guess the difficulty, Judge Northcutt, that I foresee here is you can't separate the two. If you were to remove that evidence, the judge still made the comment about the nature of the testimony that was coming in. It doesn't have this, it doesn't have that, and the jury needs to.
Well, if you remove it, there's no reason for her to mention it to the jury, correct? I mean, if it doesn't come in, the jury's never going to see it. The jury's never going to have to deal with it.
I wish I could go back and undo time, but I can't. And I don't say that to be cheeky.
I have a long list myself.
Yes. My point is that we're looking at the trial that we had. And the trial that we had was influenced by the judge's comments. You can't unring that bell. Now, if this
Mr.
court
Franklin,
views-
you're into your 5-minute rebuttal time now, so proceed as you wish.
Oh, I'd be happy to stop for now, Your Honor.
Oh, okay, that's fine. Mr. Caldevilla, you're up.
May it please the court. Good morning, your honors. I am Dave Caldevilla, and along with the law firm of Liguori and Liguori, I represent Shazam in this appeal and cross appeal. Judge Northcutt, I'd like to reserve 5 minutes for my cross appeal rebuttal. The trial court's comments about the claims history spreadsheet were not prejudicial and did not deprive Geico of a fair trial. Counsel is just coming this close to saying that if a judge comments on the evidence, it's a per se reversible error. And that is definitely not the standard. There's got to be some prejudice. There's got to be a denial of a fair trial. And I think your honors get that issue. So, and I think my brief thoroughly explains Shazam's position on the nature of the judge's comments and the ramifications of them. So I would prefer to focus on two issues that are much more important, because they're not only dispositive in this lawsuit, but they're also dispositive in over 125 other similar windshield cases that are pending against Geico and that are in the pipeline of cases that are currently pending down in the county court of Hillsborough County. And Judge Northcutt, when you called this case up, you said something like, that name sounds familiar, Geico versus Shazam. It should sound familiar. Geico has filed, I stopped counting, but well over 100 appeals in this court against my windshield clients. They only won one of my, and that's the Matthew Dick case, which counsel referred to as Geico versus Superior, which I'm going to discuss that today. But the reason I'm bringing up the volume of these cases, not only in this court, but in the trial courts, and those 125 cases that I mentioned, those are just my clients. There are other cases, windshield cases pending against Geico, I assure you, in other counties too. This appeal, if you'll decide the two issues I'm asking you to decide with a written opinion, this court would have a golden opportunity to unclog that pipeline. The trial judge's comments were about the claims history spreadsheet, and I submit that claims history spreadsheet was inadmissible. It never should have been admitted into evidence in the first place. And in addition to that, Geico never presented any evidence that another competent windshield shop would have charged and accepted $378 to replace the windshield on Mr. Lopez's Toyota Corolla in Holiday, Florida. So this is a case that never should have gone to a jury. In fact, never should have even gone to trial, because my client should have either gotten a summary judgment or a directed verdict. And a written decision from this court explaining that situation would have a dispositive impact on over 125 pending cases. So let me
that assumes we're going to finally and fully agree with the situation that Geico has the burden of proof of showing the prevailing competitive price as opposed to the windshield repairer.
That's right. And there was
as part of its case.
Right. There was a decision issued just today, as I think
yes, I
are
know.
alluding to, that it's called the Geico versus Shazam as assignee of Miss Mercado case, and it was
Judge Casanueva makes an interesting concurring opinion.
Well, I think there's some significant problems with that, and I will get to those if I have time, and I sure hope I do, because It's really important. Now, and I'm going to address Matthew Dick and Judge Casanueva's concurring opinion that he just issued today. And maybe since it just came out today, maybe we should have supplemental briefing on that. If the court would entertain that, I would certainly welcome it. And I don't know if Mr. Franklin's had a chance to see that case, and so it might be worthy of supplemental brief, a short one. But in their brief, they acknowledge that the claims history spreadsheet is their key piece of evidence. And that should sound familiar because each of your honors has presided over windshield cases where the claims history spreadsheet was Geico's key piece of evidence. At every case where Geico underpays a windshield claim as opposed to a no pay case, there's two different kinds of cases, short pays and no pays. But every case like this one where Geico underpays a windshield claim, the claims history spreadsheet is always Geico's key piece of evidence. And the cases that you all have been on before, your honors, is Geico versus Superior, which is the Fontaine case, which is Judge Northcutt and Judge LaRose. You were in that. It involved 5 cases that were consolidated. There was another one, Geico versus Shazam, as assignee of Kanopka, and Judge Northcutt and Kuzam, you were on that case. These cases are cited in my briefs, by the way, but I'm happy to give you the case numbers if you want them. And there was also the Geico versus Glasgow as assignee of Mercado case, a different Mercado than the case that was decided today. And that involved Judge Kuzam. In those prior appeals, I received favorable PCA decisions from your honors. And although I don't usually complain about receiving a favorable PCA, those PCAs have no precedential value in all the pending windshield cases that I just referred to. Most recently was the Mercado case, but recently the court issued the written opinion in the Matthew Dick appeal, which Judge Kuzam was on that panel, and she concurred in result only. Before I address the Matthew Dick appeal, let me give you some additional background. In this case, the claims history spreadsheet is 234 pages long. Each page has 64 lines of transactions, 29 columns of information. If you do the math, that's well over 14,000 transactions of windshield replacements for the year 2018. So to get that document into evidence, there are several evidence code requirements that Geico had to comply with. First, the spreadsheet itself is comprised of data from invoices that Geico's third-party administrator, Safelite, receives from windshield shops and other information that Safelite receives from various other sources. Then Safelite stores that data on its computer system. So the data in that claims history spreadsheet is hearsay within hearsay. So for example, the windshield shop creates an invoice, and that invoice is sent to Safelite, which is a different company than Geico. That company processes the invoices and puts it in their computer system. The invoice is the first layer of hearsay. When Safelite puts it in their computer system, sends it to Geico, that's the second layer of hearsay. Then Geico prints that out and brings it into court. That's the third layer of hearsay. So you gotta meet a hearsay exception for every layer, not just the business record exception, which I contend it doesn't even comply with that. We also have an accuracy problem, which ties into the business record hearsay exception under the Chanel case that Judge Northcutt, I believe, wrote in a very similar situation. So the information in this spreadsheet, Geico's corporate representative did not verify for accuracy. They testified, she admitted that she did not, and she could not. Because why? Because Geico does not have any of the underlying invoices that are in that spreadsheet. Safelite has those documents. Geico doesn't. And I'll point you to the record. Judge Allen, the trial judge, specifically, since it was such a debate about this, Judge Allen asked them, well, why aren't you producing the invoices? Do you have the invoices? And Geico's counsel said, well, maybe we can check on that. The third day of trial, that morning, Geico's lawyer told the trial judge that he could not locate any of the invoices that are in that spreadsheet. That's at the record at 2415 of the record. So I could not find any of the invoices. So the documents that comprise the data that data comes from, they claim not to have them. When we request these documents in discovery, they object like crazy, refuse to produce it. They never produce it.
I don't understand that. I mean,
Yeah.
aren't you entitled to see the backup on a summary? They have to give notice they're going to use a summary, and you have the right in
Well-
discovery to see the backup, correct?
Well, believe it or not, Judge, yes, they claim it's not a summary. They say it's a data compilation, which,
I don't know
you know,
what it, but
tomato, tomato.
okay, so that's not a summary. It's okay.
Yeah, that's what we get. Okay, we're in county court. There's hundreds of these cases. We're getting mixed signals from decisions like the Judge Atkinson's decision in the Superior case.
Yeah.
But they don't verify it for accuracy. They can't verify it for accuracy because they don't have the documents. But we know that it has errors. If you just look at the transaction, this transaction, if you find it on that 200 and something page spreadsheet, take out your magnifying glass and you'll see that this transaction, the replacement occurred on January 11th, 2018 in Pasco County. The spreadsheet at page 15 of that spreadsheet says the date was January 17th, and there was in Hillsborough County. So the very most relevant transaction on that entire spreadsheet has inaccurate data right on it, glaring inaccuracies. I'll give you another example. Judge Kuzam, you were on the Mercado case. That's the case where we allege that Geico engaged in evidence tampering with respect to the claims, the history spreadsheet. The windshield case in that case involved a 2015 date of loss. The spreadsheet said it was 2016. Just a glaring inaccuracy about the very most important transaction. And this spreadsheet was electronically created and is created with information provided, as I said, from windshield shops through to Safelite, passed along to Geico. And under the Chanel case versus Deutsche Bank, which I believe, Judge Northcutt, you were the author. You're definitely on that case. You said that no, you have to have somebody actually testify that they verified this data that's being passed along from company to company. You have to have somebody testify the accuracy. Geico never does that. Geico cannot do it. So for that reason, they don't meet the business records hearsay exception at all. But let's say they did. Then we get to the other requirement that okay, well, it's a summary. So as a summary, you have to call a qualified witness. Case law says qualified witness is the guy or the woman who actually created this spreadsheet. They didn't do that. They have to give written notice that they're using a summary. Didn't do that. They got to produce the underlying data. Didn't do that. Cannot do it. They never do it. This court, therefore, should write a decision saying, look, if this document is going to be admitted into evidence, it has to meet all these requirements, not just the business records hearsay exception. It also has to be relevant. I mean, how many transactions in this 240-page document involve 2016 Toyota Corollas? Not many. Not many. They're all irrelevant. Not only that, the document doesn't indicate whether the windshield shops are competent, which is, that's not a standard that we created. Now I'll get into whose burden this is. I've cited probably 14 cases in my brief saying that in insurance litigation, there's a shifting burden of proof. We have a policy that says, look, we will pay for a windshield loss, and there's no deductible. Then there's a limitation of liability provision. That limitation of liability provision says that, look, we'll pay for the loss, but it will not exceed the prevailing competitive price. Let me suggest to your honors that any time in any kind of litigation, not just insurance, but insurance is very clear. Like I said, I cited 14 cases, but in any kind of case where the defendant is claiming some type of a cap, either a contractual cap or a statutory cap on the amount of damages, that is always an affirmative defense. And Judge Casanueva's concurring decision that came out today, I would love to write
well, I guess the point is whether or not Shazam as the plaintiff has to prove as is in this case in chief that it supplied a price that met the cap set in the contract.
Right, and we don't. And I'm reading just the case that Judge Casanueva cites in his concurrence, but he doesn't follow it. With all due respect for him, I respect him a lot. It says, he says, our Supreme Court has held that an affirmative defense is a defense which admits the cause of action, but avoids liability, here's the key language, in whole or in part by alleging an excuse, justification, or other matter negating or limiting liability. Well, that's the test for what an affirmative defense is in an insurance lawsuit. And Judge Casanueva, quite frankly, doesn't address that in his concurring opinion. And you know, I know that the other two judges, Judge Morris and Judge Valenti, did not agree with him in that concurring opinion. It's more like a dissent than it is a concurring opinion. But again, how are we going to, how's the plaintiff going to do this? Let's talk about how this could be proven by the plaintiff. Would we have to call every single windshield shop in the state of Florida and say, you know, were you competent? Would you take $378 to replace a windshield in Holiday, Florida on a 2016 Toyota Corolla and rule out the possibility that there's no competent windshield shops that can do it? Or should Geico, who says they can do it right in their policy, they say, if you call us, we'll tell you who the competent and conveniently located windshield shop is that will accept the prevailing competitive price. Just call us and we'll tell you. They never do it in court. But would that be easier for us to rule that out across the state? Or would it be easier and more appropriate for Geico to say, look, here's 3 windshield shops that would accept $378. They were ready, willing, and able to do it. We'll put them on the witness stand. Mr. Smith, you own Acme Windshield Shop? Yes, I do. I've been in business for 25 years. Ever replaced a windshield on a Toyota Corolla? Yeah, hundreds of them. How much do you charge? We charge $378 all day long.
Okay,
That's
Mr.
how they
Calavia,
could-
you're into your 5-minute rebuttal, so
I'll just
go
wrap
ahead.
up. I will wrap up and save whatever other time I have. It's time that this court, and I appreciate the PCAs, I really do, but this is a mess, and it is their burden. This claims history spreadsheet is inadmissible, and Geico never proves that another windshield shop is competent. And I do want to cite your honors now while I still have some time left. Their corporate representative was specifically asked at page 2384 of the record, 2384, question, what other windshield shop on this list is competent and convenient for Mr. Lopez's windshield on the day it needed to be done? Answer, I don't know. Okay. Their testimony was they don't know of another competent windshield shop that would have accepted $378 in the record at 2384. And that is, I submit to the court, if you will write a decision explaining those 2 points, there will be 125 cases in the pipeline. And a lot of the cases you have on your docket are going to go away. This needs to be clear. And again, I'll reserve whatever other time I have. Appreciate it.
Yeah, right at 3 minutes, Mr. Calavia.
Thank you.
Hey, Mr. Franklin?
You're muted. You're muted, Mr. Franklin.
Apologies, Your Honor. Thank you very much. To be clear, this case is not about clearing the court's docket. This case is about whether or not a trial judge can comment on the evidence and sum up the evidence. The judge in this trial did. As to the admissibility of the evidence, a couple things. There seems to be some chuckling over the reference to a data compilation, but I look at the statute 90.803(6), records of a regularly conducted business activity, paragraph A, a memorandum, report, record, or data compilation. We submit, as argued in our cross-appeal answer brief and reply, that the requisite predicate was laid down in.
Well, but let's come back to that. So you're saying, okay, this isn't a summary of what people charge for similar windshields, right? This is a data compilation for whatever it's worth because it contains no detail and no background materials. Might one argue that evidence was insufficient to prove your side of the case?
Well, that would be your conclusion, I suppose.
I suppose, but I mean, you know, if all you're doing is saying, hey, we've compiled this data, whatever it is, and printed it out, and here you go, that's kind of meaningless, isn't it, in the context of the contractual obligation?
Sure, Your Honor. It's something to understand here is that the trial court is the one that reframed this as a data summary during the trial. And we cite
Well,
to-
whatever, if you're saying it's not a summary, it's a data compilation, what good is it if it doesn't contain the, the background necessary to make it relevant?
I think in this context, Your Honor, to address your question, if the court is going to conclude that it is not admissible as a data summary, our point is the necessary predicate was laid for its admissibility under a data compilation, and we
Okay,
cite-
and let's come back to that. Let's assume that this is a quote data compilation and not a quote summary. Are they not still not entitled to do discovery into the background materials?
Certainly, Your Honor,
And do they request that discovery?
My recollection from the trial court record is that that discovery was objected to in terms
Why?
of. I admittedly, Your Honor, I don't.
So, I
recall.
mean, what basis could you object to them asking for the background for this data compilation?
As I stand here before Your Honor, I don't know what was lodged in the case at the time. I'm suggesting that that may have been the case. The idea that they were summaries and invoices needed to be produced, as Judge Allen pointed out, this was happening during trial, and she asked whether or not Shazam had ever asked for them before and whether they got those. And so as I stand here, I don't recall with any clarity as to what took place in discovery. The point, though, that I want to come back to is, again, this case is about preserving the integrity of a jury trial free from the influence from the trial judge. This is not simply a disagreement with each other over the weight of the evidence. The Supreme Court, contrary to what's being presented by Shazam, Supreme Court has said the trial judge may not remark, comment, provide remarks, information either in express terms or by innuendo as to the weight and the nature of the evidence. That's exactly what happened here. You can't separate the two, the idea that, well, this evidence shouldn't have come in and the prejudice that was caused. If the court were to agree that the evidence wouldn't come in as a data data summary, and the court case went back, I think the Superior Auto case is representative of the fact that a trial can proceed on the prevailing competitive price on the issue from the presentation of evidence from the two witnesses and experts, Dr. McClave, as well as a corporate rep.
Subject to the right of the plaintiff to cross-examine based on discovery of the underlying information that was compiled in the data compilation, correct?
I would agree.
I cannot imagine an appropriate objection to that discovery.
I'm not disagreeing with Your Honor's direction of what should take place on a remand. The critical component here is the trial was compromised, and you can't unring that bell. We can talk about all the different issues in terms of whether or not the judge's remarks were a limiting instruction or just, some random commentary on it. The judge can't comment. And I think that's what has to be maintained throughout this. So while we may acknowledge that reasonable minds can differ as to the ultimate strength of Geico's evidence, that's why we have unbiased juries. The jury has to resolve that without the influence from the judge. I think Superior Auto reinforces and underscores the potential probative value of the witnesses that were in this case. Even if this court were, which I don't think it should, suggest that the data history compilation should be excluded, it's still for the jury to resolve. It's
Okay,
free
you
to
are
all.
at the end of your rebuttal time, Mr. Franklin.
Thank you very much. I appreciate
Thank you.
your time today.
Sure. Mr. Caldavilla, did I say you had three
Yes,
minutes?
you did, Judge. And I will respect that this is just limited to the cross appeal issues. And so it is definitely their burden. Well, let me address what counsel brought up about the data compilation. He cites to 90.803 sub 6, which is the business records hearsay exception, which does mention data compilation, but you still have to comply with all the other rules of evidence.
Well, I mean, that's a hearsay exception that
Right,
doesn't
and hearsay
limit
ex-
your discovery, correct?
It doesn't, oh, certainly doesn't do that, but let's talk about admissibility first. You know, Geico acts in all these cases like once they've met the business record hearsay exception, which I don't think they ever do, but if they've met that, that's like a magical talisman that beats all other rules of evidence. It doesn't have to be relevant anymore. We don't have to prove that it's provide the underlying documents under the summary rule. You know, we don't have to worry about the double and triple hearsay in here. It's not. You have to meet every rule of evidence that applies, not just the business records, and they didn't comply under the Chanel case. And Judge Northcott, you're absolutely right. There is no good faith objection that can be made, but if you pluck the record on every one of the cases that you'll see every time the windshield shop asks, could you please explain to us how you came up with this $378 payment that you made to us, and or who else would pay this, or who else would accept this charge to replace this windshield? Objection, trade secret, burdensome, oppressive, disaster will happen if we have to produce this stuff. It's absurd, and you know, they're required to produce it. I mean, under 90.956. So even if, regardless of the admissibility, we're still in Florida as it stands today. You know, we're allowed to get discovery if it's reasonably calculated to lead to admissible evidence, which, you know, the Supreme Court is talking about changing that standard, but right now that's the standard that we have. Again, they didn't prove that a competent windshield shop would accept $378. They never prove it. Never. The Dick case, this was discussed, and I respectfully disagree with that decision. I think that Judge Kazam disagrees with everything in it except for the result, which was to remand it for a new trial for us. Judge Casanueva did a concurring opinion which disagreed. I mean, that decision is very difficult to follow, and it needs to be cleaned up. And I may not be saying that in a nice way, but I say that with respect.
Of course.
So unless the court has any questions, you know, I request respectfully that the result of this appeal or cross appeal be that the case be affirmed, or if it's reversed under Mr. Franklin's arguments, then it should be reversed and remanded for a summary judgment or a directed verdict in our favor, because that claims history spreadsheet is inadmissible unless Geico complies with all the applicable rules of
Well,
evidence.
but let me ask you, Mr. Colavia. So, you know, is the rule, I mean, as I understand the rule, party tenders evidence and the judge lets it in. They're entitled to rely on the fact that they presented that evidence, and they can argue whether it's sufficient or not, but they don't need to come back and do something else. And if that gets reversed, because the evidence shouldn't come in, it gets sent back for a new trial because the party who tendered that evidence was relying on the judge's ruling, correct?
Well, that's if you had any other prima facie evidence.
Well, you don't have to. Well, but you don't. If you think that evidence is prima facie, you don't have to come up with any more. But you might have some more in your back pocket because you relied on the judge's ruling.
Judge,
I hear what you're saying. You want to walk away with a win, but
let me address that. The competent, they have to prove, it's their burden to prove that a competent and conveniently located windshield shop would have accepted $378 to replace this windshield. And we specifically asked their witness, their corporate rep, who's the other competent windshield shop that would have done that? And she said, I don't know. And I cited that to the record. That's in the record at 2384. Right. So that guts their case. That's a directed verdict on their affirmative defense. And again, this decision just came out today, and I do think it would be prudent if the parties were allowed to file maybe a 10-page supplemental brief discussing whose burden this is.
It's obvious that Judge LaRose has read it, or at least looked at it, but you know, we may take a look and get back to you. All right, your time is up. Thank you both very much. Well-argued case.
Thank you very much. I appreciate your time this morning.
Thank you.
In order to disappear from our screens, you look at your Zoom screen, and over in the right-hand corner, lower right-hand corner will be a leave button. It's either